questions and points that has come out from the survey that NIGA did was, just a question of how to identify genuine developers and, how do credible developers operate. And I think, one of the first things that comes to mind is, I think, do they have these developers in terms of identification and how do they operate? They would have a track record of projects that have been delivered. And typically these projects, and that's something that they themselves as developers would like to showcase because it's a key, trust driver. And for us as Mayvida, this is how we also operate. We make sure that everybody sees and understands the projects that we've delivered to date, especially if it's linked to the type of project that you're interested in. So for example, if a developer is selling, apartment buildings or apartments in Westlands that are 25 floors, 30 floors, etc. But their track record to date has been in land sales, for example, then there might be a bit of a mismatch there. So it's important to have or to review the developer's track record relative to what you are acquiring from them. Generally, genuine developers also would use professional consultants. And by professional consultants here, I mean consultants who are members of, boards and registration boards here in Kenya, or even boards that are constituted abroad and internationally recognized. Here in Kenya, we have the Board of Registration for Architects and Quantity Surveyors, known as BORACS, and they function in a similar fashion that lawyers who are members of LSK have to function. They have to go through CPD points, through training. Architects have to, and I'm an architect by training, so you have to go through, to be qualified there, you have to do at least 2 years of actual on-site experience. You have to sit for a very rigorous exam before you can get the registration. And then every year or so, you have to go and sit for CPDs, this continuous professional development training sessions so that you can keep abreast to the trends. So that would be for both architects and quantity surveyors, but you also have the Engineers Board of Kenya that would register structural engineers, even mechanical and electrical engineers. So it's important to be able to verify before purchase or in the process of purchasing the quality and level of registration of the consultant is using. Typically, developers who use professional registered consultants would be credible and genuine developers as well. It's also important to ensure or to check the status of the contractors that are used on the project. So they do, we do have an NCA, which is a National Construction Authority here in Kenya, and they would register contractors and register them according to certain levels, depending on their scale, financial capability, technical expertise, number of projects, size of projects. And that scale varies from NCA 1, which is the top tier category for contractors, up to NCA 8, which is the bottom tier. And generally, for different types of projects that are either more complex from a technical perspective, or are large in the sense of the sum of the projects. So projects where tenders are upwards of 500 to 1 billion and even more than this, would require the developer to ensure that the project is completed on time and with the right quality, would probably be looking for NCA 1 to NCA 3 level contractors, because then they themselves are protected from any risks that can come from using contractors who are not fit for purpose. So that's a really important point, especially for off-plan sales. And I think we would have all seen news around buildings that have been, either structurally unsound and you see cracks forming, or just buildings collapsing during construction. So all of this can also be a factor of the two things, either the lack of professional consultants or the lack of an NCA registered contractor. I think another point that is not usually talked about is in the relationship between the developer and the contractor. Typically, genuine developers and credible developers would have contractual documentation between the developer and the contractor. And that contractual document typically is either one of two types of standard contracts that exist in the market today. There is an internationally recognized FIDIC contract. This is, a contract that, depending on the, size and complexity of the project, whether it's buildings or infrastructure, is used across the world. And the more, sophisticated the developer, the higher the chances are that they're using a FIDIC contract to engage and formalize the relationship between themselves and the contractor. And that is also something to be wary of and to check, because chances are that if they're using this international recognized FIDIC contract, they're using a tier 1, 2, or 3 level contractor and are genuine in their attempts to complete the project on time and with good quality, because that contract is very contractually, creates obligations for both parties that are very legally astute and enforceable, which is really important. And the other contract document that is also used locally is called the JBC, which is a Joint Building Council contract, and that's a locally sort of drafted standard contractual document that governs the relationship between the developer and the contractor. So even that is an important document, and is one that if you come across during your due diligence, it's important to just have the understanding of the two types of contracts that developers generally enter into with contractors. You will find some developers who will use a form of contract that is non-standard, so none of these two, where they themselves are buying the material and they've hired a labor contractor, that is someone who will only provide the laborers to build the structure, whereas the developer provides all the material. And that is also prevalent in the market. It is a way of reducing costs. But in that type of scenario, the buyer is also not protected, because there is no contractual obligation to the labor contractor on the standard of quality of materials that are provided for construction. So it's left to the developer to make that decision, and that can sometimes be dangerous in terms of the construction and the suitability of the building for occupation, or the strength of the building during the construction period. So that's something to look out for. And generally, developers would have either one of these two types of contracts in place between themselves and the contractor. An extra boost to review and to expect, depending on and this is relating to the strength of the contractor. And most developers who are engaged on a FIDIC or JBC basis for complex structures, high-rise residential buildings, who are genuine, are also trying to protect themselves from issues that may come from the contractor's quality and ability to build on site. And usually that form of protection comes in the way of a performance bond that the contractor has to advance to the developer. A performance bond is basically saying that if the contractor does not perform in very specific ways, that is, there's an issue on site, there's a material issue on site that has raised concerns, and the value of repairing those issues is of X amount, and the contractor is not able to raise X amount, then he, as a developer, is able to either call the bank, if it is a bank-based performance bond, or the insurance company to replace that value. And that means generally the developer is protected in that form, then the buyer is also protected in that form, because there are many cases where without that form of contract and without that particular clause in place, the developer is left to his own devices. So if there are issues on site, he has to raise the capital to then fix those issues. And without being able to increase the prices of the units, then he's having to look for other sources of finance, and that can be a problematic issue. Again, an added bonus when you're looking to identify genuine developers is developers who have a corporate structure. Generally, this means that there's levels of governance and levels of management, from C-suite, CEO, CFO to senior managers who are experienced in different sections of the development, whether it's project management, finance, development management, etc. And so generally those developers that have that kind of corporate structure may appear to be top heavy, but they are also serious about the business they do because of how they are set up. Unfortunately, in Nairobi, generally developers don't have that type of structure. You might find that there's a developer that is family owned, that is it's a not an institutional sort of setup, and that can raise challenges in the future. The corporate structure also gives you transparency. Generally there will be a lot of reports issued on progress. They will have a physical office, so you can visit and actually see people moving around. I think that's also an added bonus. And it's also reflected in the tier of law firms that they will be using to, across the different development stages. So whether you're engaging as a buyer with a qualified and professional law firm that has years of experience, generally that will be reflected by the type of developer that you're engaging with. So that's also something to look out for. I think those are the key points that I thought around this particular question. There's the second question that the second point that I was asked to deliberate on is, how can buyers verify developers and particular projects? From where we sit, and this is what we even advise our own buyers. The important thing, the way we do it is to ensure that this information goes out even before the buyer has signed a letter of offer, so that even as they're deliberating at a letter of offer stage, they have enough information to do their own due diligence. So we will issue, land ownership documents. If approvals are in place, we'll issue the statutory approvals that cover both the architectural and structural approvals, which is also important. People focus on architectural only, but structural approvals are also important. There's an EMA approval, and including the Gazette notice to show that the process was followed. And prior to construction, the contractor has to obtain the National Construction Authority approval. So this information really helps. And even in terms of the process of acquisition, whereas if you're coming in at an off-plan basis and you're coming in very early, there might not be all these documents, but then that should reflect in how much risk you're taking from a payment perspective. So if all of this information is not there, then the developer shouldn't expect you to pay 20%, because then you're putting 20% of your own hard-earned money as and you're taking quite a big amount of risk. So typically we would ask for a lot less, because we understand that this information has not been provided. So, but then the moment we get this information, whether it's approvals, all these things, then we make sure to ensure that buyers, so they gain more confidence and are able then to proceed with the purchase, get this information for their own due diligence and checks. The other thing is on the sale agreement documentation. I think one thing that is not followed or not pursued by lawyers and buyers lawyers is just going through the contract and ensuring that the unit sizes, the dimensions of the unit that you're purchasing, whether it's an apartment or townhome or anything, is documented in the sale agreement. That's really, really important. The good thing now with the new system or the new regime from the lands office and how the government has set up the SASA portal and the georeferencing requirements is that once the building is completed, there is a requirement to actually measure each unit, and you can then use that to verify the the unit that you've purchased and the sizes that you've acquired. So you are buying a 50 square meter one bed. That is, this is the size that's in the sale agreement. And by the time you're, getting your unit and the unit has been georeferenced, you can then verify that the size is matching the what's in the sale agreement. So that's really crucial because, there are shortcuts that are taken in this particular vein. I think the other thing is just ensure you can get information during construction, regular updates by the developer. If you have friends or relatives or even local legal representation, can visit the sites to verify that the reports that are issued are actually on the ground, progress, and that's crucial. One rule of thumb that we advise even our clients, so that even as we're sending progress updates, it's also good for you to track whether there are delays on construction. But one rule of thumb, generally when the building is still coming up, that is, the building has not reached the top floor in terms of construction, is that generally the speed that a constructor or contractor would take to cast a floor is one floor every 20 days. So if they're on 4th floor, 20 days later, they should be casting the 5th floor. 20 days after that, they should be casting the 6th floor, and 20 days, etc. Go so on and so forth. And so you'll be able also to track progress in that very simple way, see if the developer is actually progressing with construction, or you can even see if there are delays. I think one thing that we try to get our buyers to do is actually sign up on milestone-based deposits, so that even if you're paying through construction, you know that the next deposit is required when you've reached 4th floor as a developer. So when I reach 4th floor, then you can pay. When I reach 7th floor, you can pay, so on and so forth. So that's how we also try to protect our buyers. And then the other thing is just to ensure that you have legal representation. Once you've decided to acquire a property, make sure that at that point, before signing any documents, that you've actually brought on board their legal counsel, who can then start reviewing the information that is provided by the developer before you put pen to paper and send in a deposit. And so you find that sometimes buyers will only engage legal representation when the sale agreement has been issued, but you already committed yourself to paying a deposit at the letter of offer stage. And sometimes that can expose you to those kind of issues if at the sale agreement stage there's problems or things that you might have overlooked at the letter of offer stage, but you've already paid a deposit, and the developer says, well, you paid a deposit, I'll refund you, but I'll refund you less X amount. So I think just in terms of how you can verify developers and projects, I think those are the key 4 points from our side, even how we advise our own clients. The next point that I want to address is the key risks in off-plan purchases. And I think given the history of developers in Nairobi and in Kenya, not completing projects on time, not completing with workmanship that has been promised, this is becoming now, over time, the number of developers who are having these issues is reducing over time, which is a good thing, and speaks to sometimes that the developer quality is going up. But I think that's one key risk, right? So you've agreed as an investor or owner occupier, you're purchasing a unit hoping that it'll finish in 2 years. So if the developer takes 3 years, 4 years, 3.5 years, this kind of thing can impact you from as a purchaser, and you have no real way of knowing whether he's going to complete on time by the time you're coming in off plan. So all the points that I've raised in the previous slides can help you make a decision on this. I think the other risk is, during off plan, and even as people are going through construction, it's been known to happen that developers may change the designs, may, make changes on the floor plans, or, reduce the size of the swimming pool and things like this. And this has a material impact on you as a buyer, because then you signed up on the basis of something very specific. And then when the finished product is there and you realize, oh, there were so many shortcuts made. And so, I think a lack of communication can really impact that. And if you're not checking in to see how things are going, if the developer is not progressing or providing updates like this, it can be very problematic. I think one thing to look at and to be aware of as a risk for yourself as a buyer is also in the event of default from the buyer side. So if you'd committed to make payments over a certain time or over a certain schedule, what happens if you're, for whatever reason, unable to complete those payments on time? What happens to the amount of money that you've already paid? So if you've paid 40%, but you're not able to pay the 60%, how does the developer treat this? And I think that's something that, is a key risk. The other thing that you have to manage also is in terms of an event of default from the developer side, that is, they don't finish on time, but you've paid 70%, 80%, what happens to that? What we've seen being introduced now from a sale agreement perspective, and is also based on international standards, is if it's an investment product or if it's an owner-occupier product, if I don't finish on time and it's 6 months, 9 months, then after a certain point of time, you as a developer should then pay me rent until you can complete the project, right? So we're seeing a lot of, especially foreign investors who are accustomed to this sort of clause in the agreements, in the markets that they are, insisting on these being there in the contractual documents. So I think some of this can really be helpful from a risk perspective, because at least you're covered in terms of the payments that you can get if the project delays, despite there being progress. Obviously, another thing, two things, I just want to lump them all together because they speak to the same issue. Sorry, excuse me. Poor quality workmanship that can lead to structural defects, that can lead to you getting an inferior product based on what you've seen in the brochure. The good thing is that I think there's been case law in the recent past in Nairobi, where buyers in the development who were promised certain amenities, actually take the developer to court based on what was represented in the brochures versus what has been implemented on the ground. And the courts have ruled in the favor of the buyers. So even from a regulatory perspective, the ability to hold developers to task in terms of what they promise you during the off-plan stage of sales and what they deliver in the completed project is increasing, which is a very good development. It just adds more protection for you as the buyers. So obviously, I did mention that Mivida is part of the KPDA, and what is its role today in promoting professionalism? I think through various interactions with them, they, for all their members, developers, and all these things, they require developers to engage only with qualified and registered professionals. And in fact, they would be onboarding these qualified and registered professionals, and through networking events would look to put those professionals in touch with the developer members that they have. And usually that form of interaction really helps. They also do a lot of continuous professional development so that people are aware of the emerging trends as developers, what solutions there are, what risks there are, from construction costs going up to different methods of procuring, materials and different sources of those materials in terms of markets, whether it's China, whether it's Egypt, all these things that have been very helpful for us as a developer. They also strongly, part of the membership requirements is also that developers have and maintain audited financial records and implement financial controls, and that is one of the things that they sort of insist on and encourage members to have. But I think one of the important things that they do is also lobby both the government and county governments and even developers to ensure that at least whatever rules and regulations there are that are there in place today are followed by developers in the market, and you find that there is today in Nairobi a bit of a confluence behind, the state of the infrastructure versus the amount of development that's happening. So the amount of development is far surpassed the infrastructure that's there in Nairobi. And so those are some of the challenges, and they will be sort of at the front of trying to lobby government to review these issues and to try and find solutions for them. And so far, there's been quite a lot of engagement in that regard. So we do attend a lot of these sessions and meetings with different government bodies to try and really push Nairobi's built environment into the right direction, so that we can have a city that we are proud to live in and invest in. So we do look forward as well to some of those bearing fruit in the
Yes, so I was invited to discuss the land buying process, and also to highlight certain instances of fraud, or when fraud can be materialized, or what could lead to it. And so I'll start off the discussion with the process, the land buying process. I hope you can see my screen once again. And generally, the land buying process, I like dividing it into 3 stages. And that is the pre-contract stage, the contract stage, and the post-contract stage. And Mr. Momo had alluded earlier on the importance of engaging a legal counsel from the onset when you're undertaking the project. And so that you don't come, as you highlighted, that you come when you're already looking at the sale agreement, and by the time you're being issued the sale agreement, if you're doing an off-plan or a development purchase, you'll agree with me that by then you'll have been issued a letter of offer, which would have probably signed. And so the pre-contract stage is supposed to address those issues that you're supposed to do prior to entering into the contract, prior to you executing the sale agreement. And so, of course, materially, majority of us will know that we normally, or it's advisable that you do searches. Unfortunately, most of us know the search you do at the Ministry of Lands, or what you're calling the legal search. But there's also a historical search. Yeah, much as you'll obtain from the lands registry or the lands register the current ownership status of that property, and you'll confirm that it is indeed Felix who is selling you this property, registered as the owner of that property. It's important for you to know how that property ended up with Felix. And that's why we talk about historical search. And so historical search, you won't find that entry reflected in the lands register. And so historical search is something like having a discussion with the vendor, trying to establish how did this property get to you. Yeah. So that if you're saying the property got to me from my deceased father, then the next thing you should be asking me is whether we did succession, upon the demise of my deceased father. We do succession. Because the moment I tell you the person who sold me that property, or the property ended to me from a deceased estate, and there was no succession done, then there is a question on the legitimacy of that title. And so that is part of the historical search. We also say that if it's possible, just go and have a site visit. And if you can get the village drunkard, ask him a bit historical perspective of that property. The village drunkard will be very honest with you. He will tell you this property belonged to so-and-so. Before it ended to this person, there was a dispute. And so if there was a dispute, it will be important for you to know how was that dispute settled. Or if there was none, then you'll know the title has transitioned peacefully through and through. And that's part of the searches, the pre-contract we are talking about. Of course, I've also said the pre-contract also property inspection. And again, Mr. Momo had said, and if most of the time you see people saying, you know, I used to send money. I sent money to person X to buy me property. They sent me photos of the property. And so for me, the first question I normally ask you, if you want to retain me for my services, is, have you visited the property? You know, Waswahili say mbuzi hauzwi kwa kamba. You have to see the mbuzi, not me just showing you the rope. So have you visited the property? Have you seen it? Have you confirmed that the property indeed exists, where it exists? It's because when you visit the property, you're also able to establish things like, this property, is it around government installations, for instance? Because if it's around, say, a railway, then you want to ensure at that point that there will be no subsequent demolition because you sold a Kenya Railways property. So it's important that you go have a physical visit, physical inspection of the property, not just the documents that I would have sent you, being a copy of the title for you to do your search. And the courts have ruled that a property search goes way beyond the legal search as we know it. And there's more for you to protect your title. And I often advise clients that when you're buying a property, you have to ensure that the title you're obtaining from that transaction is one that your children and your grandchildren will be able to defend in the future. So if they can't defend it, then you have to make sure that it can be defended. And if there's any questions, it's at that point that you probably should consider walking out of that transaction, not when you are already in the contract. Yeah. And that's you also need, and again, I'll keep referring to Mr. Momo because there are certain things he highlighted. Things like, you know, dimensions. When you're doing the contract, the sale contract, they ordinarily will highlight the dimensions of that property. But because the titles, the copy of that title will already capture that, you know, the dimensions, is it 2 acres or the acreage, it's also important for you to do a resurvey of that property at this stage, so that you ensure that what the dimensions you have on the ground and the map, yeah, also get a copy of the map, measure to what is reflected in the title. Okay, so that conclusively, you know, you're buying the right thing that fits the exact same description. Okay, and importantly, I want to highlight the financing option also at the pre-contract stage. And it's important to, and this is also important that you retain a legal counsel from the onset, because part of what we'll be discussing with you as the buyer, we will want to know, how are you going to finance this transaction? If you're taking a charge, if you're going to do a loan, then there's a different sort of discussion around it, because if you're taking a loan, it means then there's a financier somewhere. And so the financiers advocates will also need to be involved in these particular discussions. If you're saying you're going to do a cash sale or a cash purchase, then there's also a need to ascertain if you have the money, and we know money often has a way of moving around quickly. So there's at that point that we'll then consider the option of having a joint account with the purchase or the vendor's counsel, if they have one. So that it's important. Also, part of the financing options is for you to know that if the property is being sold to you at X amount, you also need to, at that point, be clear that there are certain tax obligations that will be accruing from that transaction, that you, as the purchaser, will be paying the stamp duty, and the vendor on the other end will be paying capital gains. So it's all part of finance discussions. These are things that should be happening from the onset. And then there's in practice, there's power of attorney. For instance, you're buying a property, or even you are selling, because let's not put the discussion towards the purchaser alone. You also need to consider a vendor who is selling a property. They are away, out of the country, or you are buying, you are away from the country, and you want to entrust person Y with that transaction. And so you give to them power of attorney. And we have seen people crying, I gave a power of attorney and now this person has refused, or they sold the property, they have not sent me the money, or they have sold way more than what we had agreed. And so power of attorney is very special because it details who's to do what, the nature and the extent. There's a limited power of attorney that will say you only sell or you only execute documents in relation to this particular property so that it's not exceeded. So if your intention is to donate your power of attorney, those are discussions that are to be had at the pre-contract stage. Yeah. So I hope that particular first stage is clear. And the second stage, now you're talking the contract stage. Now you've clarified everything. You have ascertained that the property is in existence. You have ascertained the historical perspective of that property. And now you've convinced yourself, you've persuaded yourself that you're going to enter into that transaction. And so that's where you now start executing a contract, the sale agreement. And the sale agreement generally is a very detailed document. It's the agreement between the vendor and the purchaser. It details the, terms like payment, the purchase price, who is to do what, obligations, dispute settlements, and all of that. And so in practice, or a contract as we know it, is an agreement between parties. But increasingly, there's a practice by these developers. They issue you what they term a standard agreement. But it's advisable, and I find most of them very reasonable, that they are flexible to adjust that agreement. Yeah? That you tell them, this particular clause, I have an issue with it, can we adjust it? Because a contract is between parties, yeah? And it's very unique to the two of you, and that's why you might end up, you pay, you have an enlarged period of payment as opposed to someone else, and that's because you negotiated your contract to cater for your financial difficulties, so to speak. And so when you enter into that contract, and there's a tendency where people extract contracts from the internet because they exist, and then you just go and sign it, or you ask somebody, can you draft me a sale agreement? And that somebody you asked, because probably it's a cyber person, they have interacted with sale agreement. They just throw a document at you. Of course, there will be a mention of a land. It will say their sale agreement for land, but it won't be so detailed. It won't describe the property sufficiently. And that is the importance of you retaining a qualified counsel or advocate for that transaction, because we know how a sale agreement is supposed to look like. And allow me to digress slightly. While you're engaging a legal counsel, it's very important that you ascertain yourself as to their qualification. And qualification doesn't mean what do they practice, but qualification in the sense that, is this person indeed an advocate? Okay, we have had instances where people engage, say, clerks, registry clerks, conveyancing clerks. But I can tell you, those conveyancing clerks, they're knowledgeable because that's part of what they do. We send them to the registry. We send them to follow up on documents. So they know documents. But are they qualified persons? And if you look at the Advocates Act, for instance, it has defined who a qualified person is. One must be a duly admitted and registered advocate. And so for instance, myself, I am registered, and we normally have a P105. Yeah. So if you do through the LSK portal, if you do an advocate search, you are able to ascertain that the person before you as standing out as an advocate is indeed an advocate. One, that is the first limb, is he is admitted. Secondly, they have an active practicing certificate for that year. And there are so many cases where documents, specifically transfers, were drawn by people who didn't have practicing certificates for that year. And so the transaction will initially, previously it will be invalidated altogether. But the Court of Appeal, I believe in 2019, said the transaction can proceed, but there's a disciplinary process to be undertaken against the person who drew. But remember that disciplinary process can only aid you if you are dealing with a duly admitted advocate, not somebody who is an advocate. And so what should we be looking for in the sale agreement? Of course, you said you have negotiated, you've agreed on the terms, there's a meeting of the minds in drawing that agreement. It should be executed properly. Both of you should sign. And it should also contain, there's such specific clauses that you should be looking out for. And that is on the purchase price. The purchase price, how much is it? How much is it quantified at? How is it to be paid? Is it a 10% deposit? And the balance, how is it broken down? How do we pay it? And so that all should be captured in the sale agreement. Remember, the sale agreement is the point of reference. And just to highlight how important a sale agreement is, in the Contract Act, it's only the a sale of land transaction that requires a written agreement. And so if you don't have a written agreement in a sale of land transaction, you will never prove that agreement. That's how important a sale agreement is in land transaction. And so, we've said purchase price, completion period, completion document. Completion period, basically you're saying, what's the duration when this the vendor is supposed to have done the transfer. And next to completion period is the completion date. Because once the completion period, normally it will be 90 days, but again, back to contract negotiations, you can put it at 90, 120, depending on the complexity of that transaction, or also the financial aspect of it. And so you'll say within 90 days, the contract of this transaction should have been completed, meaning you, as the buyer, you will have paid the full amount, and then the vendor will have done the transfer. And so you'll exchange the completion document. Normally it will be the transfer, copies of IDs, rent clearance certificates, rent clearance certificate. Yeah, so that should be there so that it's clear. Because once the completion period lapses, and that will be on consequences of breach. What happens if the completion period has lapsed and one party has not discharged their contractual obligation? You've not completed paying your, you're buying your purchase, the purchase price, the balance. So notices, rectification, and before we complete. And if in the event of termination, how do we go about termination? If it's terminated on account of the purchaser, normally there will be part of the deposit that will be retained by the vendor as the refund, and so on and so forth. And so that's the contract stage. And the last stage is the post-contract stage. Here, there's nothing much happening. We just doing the transfers. We have executed the contract. We are doing the transfer. And the exchange of completion documents, which we've already highlighted, and payment of the purchase price balance, so that everybody goes home happy. And you, as the buyer, once the transfer has been registered, and you get your certificate of title now in your name, or certificate of lease showing the the entry in your favor, you need to do a search so that the search confirms to you that this document being given to you is legitimate. Yeah, no, don't just get the title, registered in your favor, and then you sit back. Extract this is now part of your own due diligence. Do a search to ensure that the transfer was indeed registered. Of course, part of the documents to be given back to you is a copy of the duly registered transfer enclosed with the stamp duty and the entries. And that will be the brief discussion on the land buying process. It starts from the pre-contract, the contract, and the post-contract. And so the last limb, of course, I've highlighted to it in the preceding discussion, is on fraud in land transactions, specifically fraud risks, red flags, and what you as a buyer might be doing wrong, and so you fall victim of fraud. And fraud risks and red flags, when you're doing the search, and then you're issued with a copy of the, part of the initial documents that will be given to you is a copy of the title, and then you're supposed to do a search. And if you ask for a copy of that title and you're told it's not available, that should ring a bell to you. One, why is it not available? Is it lost? If it is lost, have you commenced the process of obtaining a new one? And if it's not lost, where is it? Because that could also indicate that the person standing before you has no ownership over that property. Yeah. So that's part of the risk, part of the red flags. I lump them together. A red flag is me telling you I'm selling you land, yet I can't get you a copy of that title. I don't have it. I can't explain its whereabouts. But it's either I have it, or I have lost it, or I have charged it. Because if I charge that title, that's a different discussion altogether. I'm selling you a property that has a loan over it. And so there's a need to discuss how are you dealing with that loan. Are you doing a discharge? Because then we might need to get a consent from the charger, the chargee, the bank. We'll need to get a consent from them. And so that we don't sell your land, and then at some point the bank is here to recover their property because of a loan you didn't know about. And so you need to, as a matter of priority, ask for a copy of the original title. A copy, you do a search. If you do a search, the legal search, it will return to you if there is a charge registered against that property, so that you highlight and ask, how are we dealing? What's the discussion around this charge? And sale of deceased property before or without probate, I also highlighted that I come to you and I tell you, somebody close to me passed on, and now I am selling this property. The moment it's mentioned that somebody passed on, your mind should instantly run to probate or succession as we know it. So have you done succession from this when this person passed on, or how did you end up with this property in the first place? The moment, as I already said, the moment there's a succession issue that is not sufficiently addressed, that is your sign to either abandon that transaction or delay the transaction altogether until those documents or that process is put in order. Because by law, you cannot transact on a deceased estate without going through transaction, without going through succession. My apologies for that. And the reason it will interest you to know if that property came from a deceased estate, it will interest you to know whether other than myself, there are other beneficiaries to that estate. And so are they privy to whatever, whatever transaction you're engaging in? Have you gone through the processes so that you don't end up with a property that is perennially in court because there was a sibling that was not involved in the succession process, or there was a stepmother or a stepfather, a stepbrother that was left out of the succession process, or there was never succession in totality. And so part of what we'll ask you, and it's in the historical search that we were talking about. When you come to me, I'll ask you, have you spoken with the vendor? Or we speak with them. We ask them, e-property, how did it get to you? And as they highlight them, we take note and then we ask the appropriate question. And that is, of course, next to unclear historical ownership. And you cannot sufficiently explain, one cannot sufficiently explain how this property ended up in their name. Yeah. And that's a red flag, that's a fraud risk, because it's highly likely or it's probable that you're dealing with a con man. And I have had an instance where we agreed to meet with people who held themselves out as vendors of a certain property along Thika Road. And we went there with my client. And somehow you buyers are always in a hurry to buy that property. And you think we lawyers are delaying the process for you when we slow it down. And so we met with those people. They came with an ID that wasn't theirs. So we asked, where is this woman? Because what was now turning out, they were not in any way related to that property. And they had an idea of an old grandmother that they said was disabled. And we asked where was, the grandmother or the lady. Also, the explanation was not sufficient. And so for me, I just told the client that we can't proceed with this transaction. Yeah, there is an issue here. We can't proceed. And so the historical ownership perspective is very important. And what we also highlighted, when you do a visit to that property, you're looking out for government or public land, probability that you're being sold government or public land. Because we know when you have a government land or public land, of course, demolition is almost always inevitable. It will happen. It might not happen immediately, but it will happen. And so you're looking out for, is it a Kenya Railways property? Is it adjust to, a road reserve, a forest? Are we selling new forest? There's a case somewhere around Gigiri, a former minister who sold or bought off part of Karura Forest. It's in the public domain. National Park, we could be having you off part of the Nairobi National Park because we say this, prime property in Langata adjacent to Southern Bypass, and you ran into buying it without knowing that it was in fact part of the national park. The government always gets its land back. The long and short of it, the government will always get its land back. Incomplete documentation. The document, again, I like using succession as a point of reference. And or if I'm giving you a lease, I'm telling you I got the lease from the government, but I can't show you, there's a document, I've forgotten the name, that you're normally given by the government before you regularize your ownership by way of a lease. It's not there. So as long as the documentation is not complete, then that is always a red flag. It's always an option for you to walk out. Actually, it's not an option. That's what you should be doing. You should be walking out of that transaction unless it's sufficiently explained to you why it is so. And that explanation should be verifiable. Because, and with reference to Nairobi specifically, and in Kenya generally, Kenyans are sweet talkers. Yeah, we can sweet talk you into things that, and you buy into an existing transaction. And so tomorrow you start saying, you see, I bought land and this, we can't even get the person who sold you that land because it was never there in the first place. Another red flag will be a company property being sold to you by directors, or a director holding themselves out to be selling your property, that upon doing a search, you realize that property is registered to a company. Indeed, the person is a director in that company, but do they have authority to sell? And how do you verify authority to sell from a company? It's by way of a resolution. And how do you verify a resolution from the company? It should have the company seal. The company seal should have been attested by either the directors or a director, because now our laws allow for there to be a single director in the company. And so sometimes it's also important, because mostly in the case of single directors, somebody comes to you, they say, I'm selling you this land, you do a search, the land belongs to, is registered in favor of a company. And so you ask this person, I can see this property belongs to X and X Limited. Who are you? They tell you, well, you see, I am the spouse of the deceased director. Okay? I'm the spouse of the deceased director. And now I want to sell this property. You tell them, ideally, if they, at that point, the advice is, since the director is deceased and you have established that you are a spouse, the process is for you to start at the succession stage, so that then we regularize share ownership, we get you in the company, so that then it's only then that you can transact, you can then sell that land. And so it's when back to incomplete documentation and ownership issue, because that's where fraud happens. Fraud happens on ownership questions. When ownership question is not satisfactorily answered, that's where fraud will happen. And so what I should be getting at the end of my discussion, what do buyers do wrong? Yeah, what do buyers do wrong? And the first one is failure to do proper due diligence. And back to what you're saying, you don't do sufficient search, you don't visit the property, you're sold land or property in theory, and most also when you're talking off plan, for instance. And off plan, just to highlight what Momo said, make it a habit to visit the site. Okay, because when you're engaging in an off-plan transaction, you know you're buying a belief. Yeah, you're buying a belief that in so many months, so many years, a property will stand here. It will have 10 floors, and the 10th floor, I will have a unit there. Or this is a gated community. So many units will be constructed. The corner unit will be mine. Essentially, you're buying a theory. You're buying a belief. And so make it a tendency, make it a good practice to be visiting. And if you are away, find someone to be visiting the site on your behalf, somebody you very much trust. And since this is Kenya and you can't trust one person, people are always colluding, have so many people that do not know of the other's existence. Yeah. You know, unbelievable as that advice might sound, it's proper. Have somebody who doesn't know of the other, so that if I come and tell you, you know, today I was at the site and I saw there were, what is it called? Is it called the, you know, Linton or something? And then the other person comes tomorrow. Naiga, I'm almost winding up. I've seen your hand. If I come tomorrow and say, you know, I saw the property, it's coming up well, and then the other person comes 2 days after and say, well, there's no property there, you know? So it means one of them must be lying to you. And so if one of them is lying to you, you need to verify. And that's why it's important for you to have many people who don't know the other person's existence to be doing the site visits on your behalf. The other thing that you're probably doing wrong is failure to engage competent professionals. And this is this one I've really highlighted. And at what stage do you engage them? And that you already said at the onset. You've gained interest on a property. Retain them at the onset. And for me, as a matter of practice, there are these people who come to you and say, Wakili, I need I need a sale agreement. As a matter of practice, I do not do sale agreements. It's either I'm doing the whole transaction or I'm not doing it at all. And this is why. You come to me, you say, I need the sale agreement. I say, okay, for this, because you want to save money, for this, I'll charge you Y amount. And then I ask you questions about this transaction of yours. And it emerges that actually what you're telling me it will be against the professional conscience for me to advise you to proceed with that transaction. Okay? From what you're telling me, for instance, this property is being sold to you by a spouse to a deceased director. But you see, at this point, you've way advanced that the only thing standing between you and property ownership, according to you, is the sale agreement. And that's the only thing that you require. And then tomorrow, when your title is challenged, you say, well, I went to Wakili so-and-so, and they gave me the sale agreement. And so as a matter of practice, we either do the transaction from the onset to the end of it. I don't do, you know, and it's good practice, don't do the sale agreement alone, or somebody comes to you at the point of a transfer. You don't know the content of the sale agreement. You don't understand the nature of that transaction. Yours is to witness a transfer. So that from a professional standpoint, it's not advisable. And so it's advisable that once you gain interest in property ownership, retain the services of a professional so that you advise properly. And professional much I've spoken from a legal standpoint. You're talking of professionals like people within the industry, like Kinamumo and Co, or architects, you know, people who understand, yeah, so that tomorrow your property is not coming down because you bought a swamp. You know, if you got the proper people, they would have told you but that by this vegetation or the general topography of this place, this is a swamp. So if you're buying into it, you need to think about 1, 2, and 3. Of course, failure to heed professional advice. Again, Kenyans being Kenyans, and if there are also people who are not Kenyans, humans being humans, we tend to heed, to ignore, as I said. You know, you think of this professional as persons who only want to earn out of you. And so you quick to dismiss their advice because fundi so and so said, you know, hii kazi tumefanya na tumekuwa tukifanya hivi. We've been doing it like this through and through. We've been using, I don't know, and again, Momo will correct me. We've been using this particular type of metal rod. I don't know, I hear there's D4 and D so and so. We've been using this one when in fact the proper one that was needed for that that particular level of construction was a different one. But because Fundi XY has told you we've been doing this and this is what we've been using, you've ignored the advice given to you by Momo. And Momo said he was an architect. You've ignored the advice given to you by Momo. You've ran to what Fundi Matendechere said, and sorry if there's a Matendechere here, it's not a reference to you, what he said. And that one you've ignored in totality. And so when things start biting each other tomorrow, you come back to you know, Architect Momo for rectification. Now, of course, at that point, it's going to be twice expensive for you. And so it's part of what we do wrong. We're ignoring professional advice, lack of presence in the ground that we already said, that you trust your brother so much that you don't see the need to verify information from them, that you, in fact, you're buying land virtually. And by the time you're waking up, yes, the brother bought the land, but surprise, surprise, the land is registered in his name. At the end of the day, who transacted? He did. He sent him money, but he paid. So the records by the vendor show, this is the person buying the land from me, and this payment is received from him. So if you're not present on the ground, it's always a risk that you should look out for. And of course, signing a power of attorney, we already highlighted that. Without you understanding the nature of implications, you end up donating much more authority than you intended to, much more rights than you actually intended to. And doing it is almost always you know, an expensive job that could have been avoided altogether. Again, if you retain competent professionals in the form of advocates, you would have been advised sufficiently on the nature of the power of attorney. And the other one, the last, second last point, being hurried into a transaction. You know, there's this thing you say, this is hot cake, and you already have, I have another buy on standby. And so if you don't buy it, I'll just sell it to the other person and you'll miss out. And, my point of concern at that point is, if you missed out on this property, what is the worst that would have happened? Wouldn't you then just buy another property? Yeah, it's specific to Kenya. Kenya is so vast. Yeah. So lucrative as the deal might sound or might feel, don't be hurried, 90% sold. And so there's only 10, or out of 15 units, there's only 14 units have been sold, or 12 have been booked with the X amount paid for. Don't be hurried. And because if you hurried, you're going to skip certain stages of that transactions, like due diligence. You'll skip them. And at that point, you might, you might fall into the fraud trap that you maybe wanted to avoid. And then, of course, blind trust in the buyer. This is the final point on what you do wrong. Blind trust on the buyer, appointed attorneys, agents, family, friends. You trust these people so much that you don't feel the need to verify. If you sent somebody X amount to buy material for you, for instance, or to pay the vendor on your behalf, or to pay stamp duty, it's only proper that that person comes back to you with a receipt of payment. But because you trust this person so much, you don't ask for this document, the receipts, for instance, so that you can verify that indeed that payment has been made. You don't ask for acknowledgement from the buyer that they've received that money that was sent to them. And so blind trust is also something that we do wrong. And with that, I've come to the end of my presentation. I hope you found it useful and one of interest to you. And so I say thank you, and invite any questions if there are any, as I return the platform to